Good afternoon, friends. Welcome once again to this afternoon session on this very important discussion point related to law and environmental sciences. Now, as part of our course module, we have seen several aspects which deal with the interlinkage between environment and various aspects of international law. Now, the evolution of legal principles dealing with environmental sciences or environment as such has quite a long history. And this history often goes out to tell us that the linkage is indeed very deep. Just as any other natural science may have a linkage with aspects related to environment, the human society and international relations in particular, when it comes to deal with environment, has a lot in common and lot of interlinkages actually come in and creep in to these areas. So it is very important for us to understand how this interplay actually takes place. Now, as a part of your course, we have dealt with several seminal cases related to environment, and some of the cases are so significant that they have changed the way in which we approach environment as such. Whether it be the Godaroman series of cases or the MC Mehta series of cases, we have seen that in all these cases there is a kind of linkage which helps us understand the importance of environment in a much better manner and how the legal fraternity as such has developed norms which effectively help us to protect the environment in one form or the other. So given that we are taking the journey a bit forward, and today we will see certain laws which apply to the aspect of negligence. Now, negligence as such you may feel does not have much to do with environment, but that's not the case. There is a lot of interlinkage between the law of negligence and environmental science as such, and we will definitely see what this is all about. Now, friends, one of the essential aspects that we have to understand is that many of the environmental problems that we have today results directly from negligence of humans. Now, why do I say so? Whether you have dirty piles forming across your road, or your city is getting dirtier, or the area surrounding your housing is in fact becoming a dirty place, or you are having big mountains coming down due to environmental negligence, definitely negligence has a major part to play in this kind of environmental degradation, and we should definitely have laws which go forward to actually prevent this kind of a scenario from happening. Now, in legal terms, what do we mean by negligence? Negligence basically in the legal fraternity has three major elements. One is non-feasance. The second aspect is misfeasance. And the third aspect is what we call malfeasance. Now let's understand each of these concepts in great detail. Now, what do we mean by non-feasance? Non-feasance is basically the failure to perform an act when it is due. Now, suppose you have a pothole on your road and the civic authority does not take any action when the pothole first emerges, then obviously the pothole will become bigger, and in due course you may have a situation where there's a big accident coming in. So that is essentially the problem that you will be facing when you have this kind of a negligence, and the first part of that negligence is in fact non-feasance as such. Now, once we have dealt with the aspect of non-feasance, the second aspect is equally important. That is misfeasance. Now, what do we mean by misfeasance? Misfeasance is essentially not performing an act in a proper manner when it is due. The first aspect, that is non-feasance, was basically the failure to perform an act when it was due. Now, misfeasance is basically not performing an act in a proper manner when it is due. There's a whole lot of difference between the first and the second principle. Now, you may perform an act which is expected of you, but you are performing in such a haphazard and half-hearted manner that the impact of that is not felt. And then also it becomes a part of negligence as such. The third important aspect is that of malfeasance. Now, malfeasance is very, very important in the scenario of environment. Malfeasance is basically doing an act where it should not have been done. That's a very important concept as such, because there are very many cases in which an individual or a group actor may actually perform an act when it was not required to be done at all, and that often causes a great deal of problem. For example, if you are in the cropping cycle, there are certain periods of time in which you are not supposed to put in uh, fertilizers, especially chemical fertilizers, because if you put those chemical fertilizers at those points of time, it will essentially kill the plant. Now, if one actually does that, at other times, basically, if you had manured the crops, it would have been a good thing. But doing a manuring job at the time when it was not expected of you and when it should not have been done is basically malfeasance. So, basically, what we are trying to say is that negligence is a combination of three aspects. One is nonfeasance, malfeasance, and misfeasance. So, you should clearly understand this concept. The second aspect that we will consider is what are the essential elements of this concept of negligence. Now, negligence has four major essential elements. One is the duty to take care. The second aspect is that the duty should be owed to the plaintiff by the defendant. The third aspect is that there is a breach of that duty. And the fourth one is that as a result of all this, a damage has actually been caused to the plaintiff. So let us see one by one. One is that duty to take care. That is, there should be a duty on the part of the defendant as regards the plaintiff. So that is number one. That is a duty to take care. There are a number of seminal cases in this regard, and two of these cases are very, very significant and very, very interesting as well. So, when we talk about this duty to take care, for negligence to actually take place, the defendant must have a duty to take care. Now, the first case in this regard is the case titled Donahue versus Stevenson. It is a 1932 case and it's a very interesting case as well. Now, what happened in this case is very, very interesting. Now, there was a ginger beer can which the boyfriend, in this case, bought for his girlfriend. And it was a seal can for that matter. It is a seal can. He, in good faith, he bought the seal can for his girlfriend from the vendor and then gave it to his girlfriend. The girlfriend obviously opened that can and started drinking the beer inside that, the ginger beer inside that. Now, what would one expect? One would basically expect that it is a smooth go, there is no problem with relation to the contents of this can. But in this case, this did not exactly turn out that way. What happened was that inside this can, there was indeed a dead snail lying in. And the moment the lady had a feeling of this dead snail being in this can, she started feeling uneasy. And once she felt uneasy, she had a bout of vomiting and she was in deep trouble. And she had to be taken care through the medical route and medication had to be prescribed for that. Now, this being a case in thought, the concerned persons then approached the honorable court and said that as a buyer, you exactly do not know what is inside this opaque can which is given to you. This you obviously when you find that the can itself is opaque and it is sealed, normally what you do is that you directly take a gulp and a drink of that particular can, and that's what the consumer actually did. And secondly, once you do that, and if there is anything within this can which causes injury to the uh, plaintiff, then definitely the manufacturer should be liable. So that was the contention of the defendant in this case, of the plaintiff, sorry, the plaintiff in this case. So the court held that Stevenson owed Donahue a duty to care, even though she had not purchased the beer directly. It was obviously bought by her boyfriend to be given to her. So the court held that obviously the producer of this product had to take enough care, had to, in fact, adhere to a duty to take care that there is no contaminated element within that can when it goes out for supply. And therefore, it was held that, in fact, Stevenson, who was the defendant in this case, was liable to be punished through a fine. And therefore, that was definitely the case in which the fine was imposed directly on the producer. Now, the another case in this particular aspect of duty to take care is basically Hagee versus the Allied Chemical and Dye Corporation, and this is a case related to 1953. And in this case, a principle was established, and the principle is that there must be a clear link between the act of negligence and the result thereon. Now, what are the facts of this case? Now, a lady who normally traverses the length and breadth of a particular city travels through a place where there is a plant from which the smoke of sulfuric acid is emanating in a furious way, and it is being released from that particular factory. She drives through that particular path, and in this process what happens is that she inhales a lot of this sulfuric acid. Now, unknown to anyone, even to the plaintiff herself, she in fact had an cancer undiagnosed cancer. She also did not know that at the moment that she was in fact suffering from that bout of cancer. She had an undiagnosed cancer, and this became all of a sudden active once she inhaled this sulfuric acid. Now, this cancer, once being activated, she had to immediately undergo a surgery, and a a medical condition developed which had to be solved through this surgery. Now, the matters came to the court, and the court held that the first and final thing that has to be understood here is whether there's a link between the act of negligence. Here, the act of negligence is basically the emanation of this sulfuric acid and the fact whether that she had to undergo a surgery. And the court held that indeed there was one, because if this particular inhalation process had not taken place, surely and definitely her need for an immediate surgery would not have been there. And she could have taken her time, diagnosed her problem, and over a long period of time, she could have, in fact, been cured without this surgery procedure at all. So, as a result of her inhaling this kind of a poisonous stuff, she had to undergo this kind of a procedure. So, the court decided that there was definitely a case in which compensation had to be paid. So this is as far as the duty to take care is concerned. Now, the second point that we have to consider here is that duty must be owed to the plaintiff. First principle was that there is a duty to take care. Second principle is that the duty must be owed to the plaintiff. And the seminal case in this regard is Borehill versus Young. This is a very seminal case which elucidates this principle. Now, what is this case about? Now, the case is very simple. A negligent motorcyclist, as we see these days, there are quite a few of them, rammed into a tram. And in many of the European countries, you had this tram system. Even in our Calcutta, we had this tram system in place. So here, this negligent motorist, he, due to his own mistake, rammed into the tram, and in the process, he himself got killed due to that accident. Now, what happened was that a pregnant lady was deboarding from the tram from the other side, and all of a sudden she hears a noise on her other side of this accident. Initially, when she was coming out of the tram, her sight was blocked from this kind of a scene, and she could not see this accident taking place. But once she turns over the bend, the picture or the scene of that terrible tragedy comes into full view. And once she sees that spattered blood all around the place, she suddenly feels sick. She feels really, really sick. She's shocked, and as a result, what happens is that she undergoes a premature delivery of 8 months. So, due to this accident, a scene is created, and seeing this scene, this lady delivers a baby prematurely in an 8 month cycle. Now, once the delivery is over, she sues the heirs of the motorcyclist that he had not performed the duty of to her by riding rashly. Now, obviously, the person who did this kind of a foolish act would not have imagined that someone would definitely be coming over. She would be pregnant in that case, and she would be, in fact, delivering the baby prematurely. That is no contention at all. The court held, and very rightly so, that it was not foreseeable for that cyclist, for that matter, to foresee that this lady would suffer psychological harm as a result of his motorcycle getting rammed into that particular tram. So here, since there was no duty as such being owed to the plaintiff, no compensation was due. So, this is where the cardinal principle comes into play. The duty must, in fact, be owed to the plaintiff. That is principle number two. The third principle is that there should be breach of that duty. And when does this breach take place? The breach takes place when the defendant fails to take standard, reasonable, and necessary care. Now, there are two cases which are very, very significant in this regard. The first case is Blitz versus Birmingham Waterworks Corporation. Now, what is this case about? In fact, the defendants had installed water mains along the street with hydrants located at multiple locations in a city. Now, it so happened that in due course, one of the hydrants developed a leak because of the extremely cold climate that was witnessed in that particular year. And as a result of that, the hydrant obviously got spoiled. Now, the leak was of such a nature that it caused inconvenience to at least some people. So, a particular person went to court and said that there is a breach of duty on part of the company which had set up this kind of a mechanism. The court held that, see, these hydrants were established or set up 25 years ago. There was regular maintenance which was being done by the company in question. And further, there is nothing to show that there was any negligence on the part of the defendant. Now, normally when you set up such equipments, you take into account the average weather of the country or the area in question. So you cannot foresee every unexpected act for that matter or unexpected event for that matter. And since he had taken all kinds of reasonable care, he had taken standard, reasonable, and necessary care by doing the maintenance properly, He had obviously expected the needs of a normal winter. And since this was an unexpected kind of an event, the company was not liable. This was the final decision of the court. Now, there is another case, that is Glasgow Corporation versus Taylor. Here, for the first time, the allurement principle was evolved. Now, what is this principle? This case, in fact, relates to the death of a young boy who ate poisonous berries from a shrub in the Glasgow Botanical Garden, which were open for the public. Now, we all know that children are often attracted to very beautiful and colorful things any place they go. So, it is always natural for the students or the children to approach such things which are very attractive for them without looking at the consequence. Now, the court held that dangerous objects on land that attract children are potentially harmful, and very rightly so. And in this scenario, they should be managed well to prevent injury. In this case, the Glasgow Corporation was negligent in the sense that it breached the duty to take standard care to restrain young visitors from consuming the poisonous berry. So, what the court actually wanted to state was that in this case, since the botanists actually knew that this kind of a berry could in fact be harmful to the children, they had to take adequate care by putting up some kind of fence or some other protective equipment so that the children do not go and consume this berry. So there was a case that this had to be the concerned authorities had to be liable. This is the third principle. And the fourth principle is that the damage has to be caused to the plaintiff. What does it mean? This means that the said act could cause damage or loss to the plaintiff. The damage can be in the form of loss of reputation, loss of money, physical injury, mental agony, decimation of property, so on and so forth. And the principal case in this regard is Joseph alias Papachan and others versus George Moonjali and other. Now, what is this case about? In this case, the court held that the first defendant was guilty of negligence in conducting an operation on a deceased person who, following the established procedure, and the second defendant for being the owner of the hospital vicariously liable for the negligent act of the first defendant. Now, what happened in this case that was that the doctor had, a doctor obviously who was working in a certain clinic or a certain hospital owned by the second uh, person in question, had conducted an operation without following the established medical norms and procedures. And as a result, the defendant, the plaintiff actually passed away. Now, the defendant, the doctor who actually conducted the operation was obviously liable. He had to be punished. But the second person, that is the owner of the hospital, was also punished because he was vicariously liable for the negligent act. Since being the owner of the hospital, he had a responsibility to ensure that the persons working under him and who are representing him acted in a judicious and a lawful manner, which in this case could not be established. So the court awarded a compensation of 1.6 lakh rupees for the damage caused to the due to negligence. Now, there are a couple of concepts that we have to understand in this regard. The first concept is the concept of res ipsa loquitur. What it means is that the thing or the situation speaks for itself. Now, what does it actually mean in a real life scenario? Even though the direct evidence may not be available, the circumstances in which an event may have happened indicates the prevalence of a certain evidence. This is very, very important. That is, there may be certain situations in which direct evidence of wrongdoing may not exist. However, the circumstances surrounding the issue may be so strong that it may indicate culpability of a certain person or a group of person or an institution. And that itself is res ispa locutor, or the thing speaks for itself. The seminal case in this particular regard is Bayern versus Bodel. This is a 1963 English tort case in which what happened was that a barrel of flour which was there in Brodel's warehouse fell on Brian and injured him very badly. Now the court held that this, and there was once the injury happened, the things were all taken away from there, and there was no circumstantial evidence to show that this kind of an injury was caused by a barrel of flour falling from Bodil's warehouse. Now, the court held that this is indeed a case of res ispa locutor, meaning that the circumstances of the case allows us to infer that a person has been injured due to the falling of this kind of a bag of flour on him. So here negligence was inferred from the circumstances of the case. So that is concept of res ispa locutor. Now there are certain conditions under which res ispa locutor is established. One is that the principle, the injury which we are talking about occurred under the defendant's control. Here, definitely the bag of flour was in Bodil's warehouse, and therefore it was in Bodil's control. Second, the event would not have ordinarily occurred without negligence. If Bodil had taken enough care to keep this barrel in a safe place, definitely it would not have fallen on Brian. Thirdly, the plaintiff cannot offer direct evidence of negligence. Now, once the injury had taken place and once the barrel had all been removed from that place, there is no circumstantial evidence left. So, there is no direct evidence that we can offer in this case, and this is the concept of res ispa locutor, which is very important again in environmental cases. Now, there are certain defenses against the law of negligence. Now, what are these negligence? What are these defenses? One is contributory negligence, where the plaintiff is equally guilty. That is, he himself contributed to the loss through his own negligence. For example, if you are walking on the road and you are having your ears plugged with earphone which is connected to a certain musical instrument, and you do not know what is happening all around you. Now a cycle or a motorcycle comes and hits you. Now you do not know under what circumstances it happened, because you are walking right in the on the middle of the road, and the person, the motorcyclist, also could have done his bit to save you from the accident. However, since you yourselves are part of that negligent act, it is in defense for the motorcyclist to argue that this accident happened due to your negligence, so you have contributed to that negligence. That is number one. The second defense is the assumption of voluntary non-fit injuria, or voluntary assumption of risk, where the plaintiff, knowing fully well that there is a risk involved, accepted that risk or the harm. For example, you know that when you climb a mango tree to pluck mango in a rainy season, there is a risk that you may slip down and fall down and get yourselves injured. In spite of knowing that it may happen, so you have climbed the mango tree, which in fact implies that you have voluntarily assumed that risk and voluntarily accepted the resultant harm. That is voluntary non-fit injuria. Third one is basically inevitable accident. This is a very interesting concept as such. Inevitable accident. What do you mean by inevitable accident? This is an accident which occurs in spite of our taking all possible precautions. This basically, there has to be a human activity involved, and that human activity, in that human activity there is a kind of accident or a loss which is occurring due not because of your fault. You have taken all precautions to prevent prevent that kind of a incident from happening, but it was beyond your control and it happened that way. So it is an inevitable accident. The fourth one is the act of God. Here there is no human intervention as such. There has been a violent, irresistible natural event which resulted in an accident and loss thereof. And therefore, we call it act of God. For example, if there is a flood, sudden flash flood, or there's an earthquake or some such activity and an injury is caused on account of that, then it means that it's an act of God and you could have possibly done nothing to prevent it. And the final defense against negligence is that there is an illegality where the plaintiff himself is involved in such an activity which is of an illegal nature. For example, um, a person goes to commit robbery inside a house and in the process he injures himself. So you cannot, the person who is doing this illegal act cannot claim that there has been a kind of negligence which has occurred against him. It is due to an illegal act which he has committed that he has been injured, and therefore there is this is a definite and a solid defense against the principle of negligence. Now let us apply this to two kinds of environmental problems. The first one is that of land pollution. We all know that land pollution is a major problem that we are facing today. If you see 97.85% million hectares or 29.7, nearly 30% of India's land is degraded. The sources of land degradation include agriculture, mining, industry, construction, households, and so forth. Another important pollution of land which is taking place is through plastic pollution these days. And added to all this, there is also this unscientific waste discharge. We are not following the 4R principle. Instead of that, unscientifically, many of the cities are discharging the waste, resulting in greater health and other problems to all persons around them. So, what is the impact? Impact is that erosion occurs by wind and water further degrades land, and pollutants obviously contaminate the groundwater and water flowing in water bodies as such. Now, there are certain seminal cases which we can cite in this particular regard. One is K.K. Subramaniam versus Laws of Ecology. This is a 2010 case in which the issue of tannery pollution was addressed. And the Honorable Court was right in stating that the owners of the tannery had to pay compensation according to the polluter pay principle. And what does this principle means? This principle in fact means that any person who knowingly or unknowingly causes pollution due to his or her act is liable to pay for the mischief that is caused by his particular act. So, in this case, the court ordered that the loss of life, crops, and property had to be directly compensated by the tanneries themselves. The second case in this regard is the groundwater case, which is very famous, and this is one of the cases which was handled by the legendary MC Mehta. So here, the court addressed the issue of falling groundwater levels in Delhi. And this particular case led to the establishment of Central Groundwater Board to regulate the extraction of groundwater, not only in Delhi, but all across the country. The third and very important case is Nityanand Mishra versus the state of Madhya Pradesh, which is a 2021 case. This was concerned with the pollution and encroachment in Chitrakoot, a very important place associated with Indian mythology and history. The court emphasized that state's duty to protect innocent citizens from pollution is paramount. So the state has an inalienable duty to protect each of its innocent citizens from pollution whatsoever. So this is as far as land pollution is concerned. Now, there is an equally or even more important problem which is associated with water pollution. Now, water we all know is the most important component for sustaining life on earth. And of the unfortunately, the fact is that of the total water quantity which is available on earth, only 1% is fit for consumption. And though more than 70% of the earth's surface is covered with various forms of water, This 1% is alone the quantum which is available for us for consumption. Now, even this 1% is rapidly depleting on account of rapid increases in population, contamination of water, pollution, and all other related problems which are being caused by human activity. Now, courts have indeed understood the importance of protection of water, and many cases are related to this issue of water pollution. But the most important case is uh, Municipal Council Ratlam versus Sri Varthijanda and others. This is a very, very seminal case. Now, what happened in this case was that there were complaints from the residents of Ratlam municipality that their municipality has failed to provide adequate drainage, sanitation, and other clean water facilities to the public in ward number 12. And added to this, there were several industries which were opening up their noxious and polluted residues into the drinking water sources of Ratlam. This was a scenario in which immediate action was actually expected of the municipality, which obviously the municipality did not take. So the residents had to resort to its complaint. Now, the Honorable Court dragged the municipality for hearing and asked them why this scenario was actually emanating. Now, the municipality raised several issues. One was that they did not have the facilities. Second, they said that they did not have the money to actually take care of that cleaning processes. The Supreme Court was very clear. They said that you cannot have a scenario where you are wasting money on litigation to go against these innocent people who are facing this kind of a pollution. But at the same time, you are not utilizing the same amount of money to provide better services to the people around you. And secondly, there was one legal issue which was involved here. Now, the question was whether Section 133 of CRPC was applicable for removal of nuisance in this case. Now, the district magistrate under 133 CRPC had the power to use his powers to remove the negligence which was involved or the nuisance which was caused due to certain acts. Now, the question was whether in such a scenario as pollution, this kind of a power could be used. The Supreme Court unequivocally stated that yes, the powers available to the district magistrate under CRPC 133 were enough to compel the municipal authorities to clean up the system and to remove the hindrance or the negligence which was being caused in this scenario. So this is a very important and seminal case, and this is a case which every student of environmental studies should know about. So this is the end of this particular session. Thank you for your patient hearing, and hopefully in due course I'll be able to bring further sessions to you which are related to the various facets of environment, and hopefully we can have very productive rounds of discussion on these very facets that we are talking about. It has been wonderful interacting with you, and I'm sure that we will be able to have a very clear understanding of environment and its dynamics through these sessions. Thank you for listening to me, and we will be shortly joining in a few days time for the next session. Thank you, Varnana.